Ramaphosa has now signed into law the National Minimum Wage Bill, but he's also signed three other Labour bills: the Labour Laws Amendment Bill, amendments to the Basic Conditions of Employment Act, and the Labour Relations Amendment Bill. What do these bills mean, and how will they affect both the employer and employee? Well, to help make sense of all of these bills, I'm now joined by Osborne Molatudi, who's an employment law expert. Thanks very much for joining us. Welcome to the programme.
Thank you, Peter.
All right, so there was a lot of controversy about the minimum wage bill, some hailing it as a victory and others saying that it wasn't so much. But that aside, the politics will play itself out. The employers and the employees have a new dispensation that they're going to come into play. Let's start with the minimum wage bill. It's been talked about quite a bit, but what would you say as a labour expert is the things that perhaps we should be cognizant of and maybe be warned about?
Indeed. You know, Peter, after years of intense negotiations, discussions, briefings by the Department of Labour, protest sections by trade unions, etc., we finally now have a legislated minimum wage, which is currently set at 20 Rand per hour or 3,500 Rand, depending on the hours of work that an employee is performing. Now, what this means is that this is a platform for both employers and employees and their trade unions to work on, take advantage of this and ensure that there is compliance going forward. And by the way, this bill was signed into law just last week, Friday, and therefore all the intense negotiations have come to an end. This is now the law. For the first time in this country, we now have a statutory minimum wage.
All right, so one issue that I wanted to clear up, and I wonder, is there legislation already in place, or is it being considered, about the number of hours that people can work? I mean, you hear stories of domestic workers who work ridiculous hours, and if they're lucky, they get one day off. Is that allowed under law?
It's not allowed. The maximum hours of work is still set at 45 hours per week. And this is something that the National Minimum Wage Act will take into account when assessing the phasing in of farm workers, domestic workers, because currently they are not on 20 Rand per hour, but they will be phased in over a period of 2 years, and more so after the conducting of an annual review by the National Minimum Wage Commission, which will comprise of all various stakeholders, for instance, three from the community, trade unions, business, and a chairperson to be appointed by the minister.
All right.
But what is also important is that there is, the Act makes provision for exemption. So those startup to small employers who feel that they may not be able to afford this minimum wage can in fact apply for exemption. But that is not there for the taking. They'll have to put up a well-motivated application to explain why they can't afford the minimum wage.
Which in the end is going to be unfair for employees, because if they work for the wrong company, they're going to get less than the next person, isn't it? I mean, that's the reality.
Well, with the regulations to be published by the minister, the employees will have a right to contest that application for exemption. Okay. So it's not going to be a one-sided application. They will still have a right to make submission and oppose it if they feel they want to do so.
So he did sign three other bills as well. Let's talk about the Labour Laws Amendment Bill. What's in there that's changed?
You know, Peter, I'm surprised that this is keeping the eyes of many employees and employers, especially fathers, because this one makes provision for a new form of leave referred to as parental leave. This is for you and me as fathers. Instead of now being entitled to 3 or 4 days, we are now entitled to 10 days as fathers.
10 working days, so it's 2 weeks.
Yeah, 10 working days. And also, the Labour Laws Amendment Bill makes provision for adoption leave, surrogacy leave, for those parents who want to adopt a child or those who want to have a child through surrogacy. And the amount of leave ranges from 10 days to 10 weeks, depending on who takes the role of a mother. So I'm surprised that this hasn't caught the attention of many critics and analysts. So this is quite progressive,
and I guess employers now have to factor all of this in.
Indeed. Our advice to many employers across the board was that you need to revisit your policies, and especially on leave, and make sure that you put in place this new forms of leave in those policies. It's very important that they do that to avoid claims of discrimination or unfair labor practice at the later stage.
All right. So what about the amendments to the Basic Conditions of Employment Act? What amendments were there?
I think the significant one there is the fact that the BCA Amendment Act simply makes provision for the National Minimum Wage Act. So in other words, if any employer is found to be paying less than the minimum wage, that employer can be fined twice the amount that will be determined in terms of the schedules on fines. And more importantly, those low-income earning employees may have the right to go straight to the CCMA if they feel that they're being underpaid less than the minimum wage set. I think those are the significant amendments. Of course, to also make reference to the national minimum wage into the definition of employment law.
And then the last one, the Labour Relations Amendment Bill.
This is a tough one. The most significant amendment in this one is the fact that thou shalt not wake up and go on strike. The Act does make provision that you need to test the support of the strike that you want to embark upon as a trade union and have a ballot. And that ballot can also take place by way of a secret. By the way, this also extends to employers who belong to an association. If they want to lock out employees, they cannot just wake up and do that. The Act does make provision that in order to test the support for the lockout, they should conduct a secret ballot. But the most significant one, I must say, is the one that NUMSA labels as the limitation on the right to strike, is where you're now going to have an adversary panel which can intervene in what is perceived as violent or protracted strike because it may be seen to be no longer in the interest of the economy of the country. And that can be put in place by application by a trade union or the employer, or the CCMA can mero motu just intervene, automatically intervene if it feels it's in the interest of the country. And those are the key amendments. The other one, of course, is on picketing, that if there are no picketing rules, you can't strike. You have to agree on picketing rules. If you can't agree, then the CCMA may intervene.
All right. Osborne, we always run out of time, but thank you so much for highlighting particularly the other bills. I think a lot of focus has been on the minimum wage, but the others are also equally important, and some of them quite progressive and others quite serious implications. But thanks very much for the clarity.
It's my pleasure, Peter.
All right. Okay, from there...